Good morning and welcome to the final day of this year's Insolvency Conference. Thank you very much for joining us this week. So far we've had talks from Iqbal Mohammed on Brexit, Mark Brown on non-Brexit cross-border insolvency issues, Chris Buckingham and me on 4 areas where property law and insolvency law meet, Ali Tabari and Kirsty White on fraud and insolvency, in particular how claimants in fraud cases can use insolvency law to their advantage, Avtar Kanguri QC on economic duress and the Supreme Court decision in Pakistan International Airlines, and Natalie Kearney sketching the battlegrounds in personal guarantee disputes. If you've missed any of the 8 speakers so far, their talks will be available on our website and on our YouTube channel shortly. Well, it may be Friday, the weekend may be around the corner, but I hope you're bright and alert. This morning, James Morgan QC will take you through a tricky case study which touches on several developing areas of the law of misfeasance. And before that, Raghav Trivedi, the newest member of our insolvency team, and Amanpreet Kaur, one of the pupils in Chambers, will each talk to you about a recent case. As ever, if you have any questions, please feel free to send them using the chat or Q&A functions, and we will deal with them at the end. Now, Raghav.
Thank you, Rob. Welcome all to the final webinar of our Insolvency Conference Week. I hope you have all enjoyed the variety on show this week in terms of the topics presented. Today, Amanpreet and I wanted to end the week with a short and swift case law update, particularly for our junior members, but also providing something for all. We wanted to discuss 2 particularly interesting cases in the field of personal insolvency law that has cropped up over the last year or so that brings out some interesting points. So I shall be discussing the matter of Hughes and Howell, a recent Court of Appeal authority which recaps the law surrounding Section 271 of the Insolvency Act and what constitutes unreasonable refusal of offers made by a debtor, as well as how that interlinks with the concept of property and security under the Insolvency Act 1986.
Hello, and I will be talking about Bucknell and Wilson, which is essentially a case where the trustees of bankruptcy ran the defence of change of position, which then was got to appeal, and how the courts approached how the defence of change of position should be ran.
So firstly, dealing with Hughes and Howell. This case dealt with Section 271 of the Insolvency Act 1986. And Section 2711 is crucial in this respect. This sets out the conditions for a bankruptcy order, as you will be aware. The court shall not make a bankruptcy order on a creditor's petition unless satisfied that the debts in respect to which the petition is presented is either a debt which, having been payable at the date of the petition or having since become payable, has either been paid nor secured or compounded for. And the concept of security is what was in consideration in Hughes and Howell. And Section 2713 of the Insolvency Act, which sets out the test for unreasonable refusal. The court may dismiss the petition if satisfied that the debtor is able to pay all his debts, and that the debtor has made an offer to secure or compound the debt in respect to which the petition is presented. The acceptance of that offer would have required dismissal of the petition, and that the offer has been unreasonably refused. So what happened in Hughes and Howell? Well, in this case, Mr. and Mrs. Hughes obtained a judgment against Mr. Howell in the sum of around £73,000. Simply put, Mr. Howell didn't pay it, and a bankruptcy petition was presented. Numerous adjournments then followed to allow Mr. Hughes to part pay the judgment debt and secure the balance. He had paid nearly £30,000, but the remainder remained unpaid. Mr. Howell's evidence at the first hearing of the petition was that his aunt had died in May 2018, and that he would be entitled to a quarter share in her residuary estate, consisting mainly of the proceeds of the sale of a house. Mr. Howell had offered to pay £15,000 forthwith and a further £15,000 on imminent closure of the estate accounts, claiming that he had given irrevocable instructions to the executor solicitors to pay all sums that he was due to receive from the estate to Mr. and Mrs. Hughes' solicitors. He claimed that those instructions amounted to security over his right to the fund as property. Mr. Howell was wrong about his entitlements, and what actually happened was that there were 5 residuary beneficiaries, not 4 as he had thought. He overvalued the value of the home, and his total maximum entitlement was found to be £46,000 compared to his figure of £60,000. Noting there to be a shortfall, Mr. Howell at the bankruptcy hearing offered to pay £10,000 to cover it. So the ICC judge held that only part of the debt had been secured at best, and that it would be several months before the shortfall could be calculated. There was no clear assurance that the petition debt would be paid within a reasonable time, and as you will be aware, that is the key test. And so the offer was not one a reasonable hypothetical creditor that could have refused. Simply put, Mr. Howell was declared bankrupt. He then appealed that decision, and this appeal was dismissed because, again, there was a shortfall, and the judge found that the property market had been falling, so the offer was considered to be insufficient. The time taken to realise the security was relevant, because Mr. and Mrs. Hughes took on the risk of the realised share of the aunt's estate being insufficient to cover that shortfall. So what did Mr. Howell do? He appealed to the Court of Appeal. The Court of Appeal recapped certain areas of Section 271, the application of those principles. The first is the default position when it comes to bankruptcies and the test for adjournments, laying out the old age test from Edgington and Secon, another Court of Appeal decision, where the court stated the starting point is that if the petition creditor establishes that the statutory conditions are fulfilled, he is, on the face of it, entitled to a bankruptcy order. So that's the default position. If one meets the procedural requirements of the Insolvency Act and the rules, then a bankruptcy order ought to follow. However, the court does have a power to adjourn when there is credible evidence that there is a reasonable prospect that the petition debt will be paid within a reasonable time. The court also stated that they will usually not accept bare assertions as to means and ability to pay. This was considered a valid long-standing practice, and this is a practical point to bear in mind for those representing debtors to produce the best evidence possible of an offer to pay in order to secure an adjournment. Further to that, the court approved of a key authority which I'm sure all of you have utilised in the past in these matters, of HMRC and Garwood, which is the 10 factors or 10 non-exhaustive factors to consider for unreasonable refusal. The key one for the court to consider, and I'll urge all practitioners to go and review that authority, and it sets out those 10 factors, 1 through to 10, quite clearly in the case itself, is factor 9. A creditor is entitled to have regard to his own interests and is not obliged to take a chance or show patience or generosity. So the focus in this case was upon the petition creditor, and the onus was placed on the debtor to provide the best evidence for his offer. And finally, the court summed up the rights of a residuary beneficiary. And in short, an executor has full ownership of property in the estate, but simply to fulfil his duties in respect of the administration of that estate, and that a residuary beneficiary has a right to compel the due administration of the estate, but not the legal or equitable interest in the assets of that estate. So, in tying this all up, the court focused attention upon the concept of security and property. Section 2832 of the Insolvency Act states that a debt is secured for the purposes of bankruptcy to the extent that the person to whom the debt is owed holds any security for the debt. So, usually this would be a mortgage charge or a lien or other form of security over any property of the person by whom the debt is owed. The Court of Appeal said that the definition of property is a wide one in the Section 435 of the Insolvency Act, extremely widely drawn to include the rights to a residuary beneficiary to compel due administration of the estate, and so this right forms part of the bankrupt estate capable of being the subject matter of security. So therefore, Mr. Howell, by him stating that part of the debt would be paid out of a specific fund coming to him from his aunt's estate, and directing the executors to pay those sums of money amounted to security under the Insolvency Act. But the Court of Appeal did make clear that this was an unusual form of security because it was not over immediately realisable funds, or immediately realisable security itself. The value of the security depended on how much was received and when it was received. So the Court of Appeal found, by applying Section 271 of the Insolvency Act, the debt had not been secured, and at best only part of it had been, and agreed with the lower court's findings. The Court of Appeal then, quite crucially, set out what an offer to pay constituted, and stated that an offer must be a concrete offer, an offer capable of acceptance, a present offer, and not the possibility of a future offer. So therefore an offer to top up a shortfall was clearly not enough. The court also stated that it is not up to the creditors to negotiate with the debtor before the debtor makes the offer. So the onus was placed on the debtor to make the offer alone. Further to that, a reasonable creditor is entitled to know where money is coming from, what the other liabilities of the debtors are, and when they need to be satisfied, and when that money will be forthcoming. So clearly the onus squarely falls upon the debtor to start off with the negotiations in respect of offers made. The creditor does not have to do anything. On the question of security, the Court of Appeal rejected the idea that if a debt is secured, it does not matter how long the creditor would have to wait before being able to realise that security, and security is only of value if it enables the debt to be paid within a reasonable time. So one can see that the court has tied up the various jurisdictional tests, the adjournment jurisdictional test, the unreasonable refusal and jurisdictional test in the context of property and security. The court also stated that a creditor is not unreasonable in refusing to wait for an indeterminate time for an indeterminate amount before the security can be realised. So simply put, Mr. and Mrs. Hughes here would have had to wait such a long time until the executors had sold the house, received the interim distributions, so therefore the amount which was at play here was entirely uncertain, or indeed Mr. and Mrs. Hughes would have simply had to wait until the estate had been administered. That was clearly unreasonable on the part of Mr. and Mrs. Hughes to accept. It was safe to say Mr. Howell's appeal to the Court of Appeal was dismissed. So where does that leave us? In terms of practical points, the headliner is one must know the strengths of the offer that has been made, particularly for those representing debtors. One must assess the offer, and clearly this case favoured the petitioning creditors as the commentary in the case has suggested. One must check that the elements of the test from the case are met in terms of what an offer constitutes, i.e. it must be a concrete offer capable of acceptance present and not a future offer. Further to that, it's up to the debtor to make sure the evidence that one presents at the hearing stands up to scrutiny. It appears when one reads between the lines in this case, it's not a simple matter of sending in a notice of opposition and turning up at a hearing. Courts will, in light of this authority, delve in deeper into the contents of the offer made. Even if one doesn't actually present any evidence, one will want to know whether the elements of the offer test from this case has been met. From a knowledge standpoint, one will be aware that many first hearings of petitions get adjourned for time to pay in any event. But one must now understand that a request to adjourn could ultimately leave the judge questioning the reasonableness or otherwise of the offer to pay anyway. The adjournment jurisdiction and the unreasonable refusal jurisdiction are now inextricably linked. The court also made it very clear that the definition of property is a wide one, and therefore an offer of security should not be taken lightly, where it appears that the offer does not really present security in the usual way, for example, a mortgage or a charge. So those are the key learning points that one derives from this authority. So thank you all for listening. If you do have any further questions, please use the chat function, or alternatively my email address is on screen, and I'll be more than happy to assist accordingly. I'll pass you now to Amanpreet to deal with her case.
Thank you, Raghav. The clicker is working. Yeah, we're good to go. So today I'll be talking to you about the case of Bucknell versus Wilson, which is also known as refolds. Essentially in this case, the court considered the correct approach to a defence of change of position in a claim by trustees in bankruptcy for relief under the Insolvency Act, section 340, in relation to a preference paid to the stepdaughter of the bankrupt. That might sound like a bit of a mouthful, but I am going to break it down, and this is where the background facts of the case become quite important. So on a Friday morning, I have a lovely flowchart prepared for you. The background facts of this case boil down to a family dispute. There was a bit of family dispute between a father and his son. And this led to, unfortunately, a bit of a messy litigation in which the son obtained judgment against his father was for around about £700,000. During that litigation, the dad actually retained his stepdaughter, Gina Wilson, to provide accountancy services. And after that judgment was entered against the dad, he paid his solicitors, counsel, and estate agent, and I think he did that by selling a few properties. And at the end of it, he had a surplus of £47,747. And yeah, he used that £47,747 to part pay Miss Wilson's invoices. And what that meant is that he left his son with nothing, who actually had made the judgment against him in the first place. And rightly so, or maybe not rightly so, he made his dad bankrupt, and he was a significant creditor left that had received no payment. So off the back of that, what the trustees did in this bankruptcy is they brought a Section 340 claim against Miss Wilson on the basis that she had been preferred over the son. So I put the law on the slides there, and I won't read it out into too much detail, as I'm sure many of you are aware of this statute. But what I have done is I've underlined the word shall, and as it appears, court shall on such application make such an order as it thinks fit for restoring the position to what it could have been if that individual had not given that preference. This seems like it's mandatory. However, in due course, we will see that it is a discretionary power which becomes irrelevant in this case. And again, just for some, just as a refresher of the law, so an individual gives preference if that person is a creditor. That individual does anything or suffers anything to be done which puts that person in a better position. The individual who gave the preference was influenced in deciding to give it by a desire to make the payment, and that the person is an associate of the individual. And for these purposes, which again is important because Miss Wilson was the stepdaughter of the dad, she was classed as an associate. So, the actual application that the trustees made. In the first instance, ICC Judge Jones actually found that all of the elements of a Section 340 claim were satisfied. He was satisfied that Miss Wilson was, in fact, put into a position in the event of her stepfather's bankruptcy, and that she was in a better position she would have been if the payment had not been made. She received a payment rather than being an unsecured creditor, proving in the bankruptcy for the amount paid. Miss Wilson failed to rebut the presumption that her stepfather was influenced in deciding to make the payment by a desire to prefer her. And finally, that the onus was on Miss Wilson to prove that her stepfather did not have any such desire because Section 340, subsection 5, applied her as his associate. However, despite making all of those elements out of Section 340, the judge had actually used his discretion and said that making of any order would be unjust. So the order in this case would have been made that Miss Wilson would have had to pay back the payment. And the facts that were relevant in exercising the court's discretion were the fact that Miss Wilson received the preference on a commercial basis. So as we remember, she was an accountant providing accountancy services to her stepfather. She was paid the least of Peter's creditors. Therefore, the usual justification for the 2-year clawback period distinguishing associates from other commercial creditors was not met. Secondly, she acted in good faith. She had no involvement in receiving the payment. She simply just received the payment. Thirdly, and this is the issue that was in dispute in the appeal that was made on the back of this decision, was that she no longer had the preference proceeds, i.e. it was a change of position. So during the trial, what had happened was Miss Wilson was not represented. She was cross-examined by Judge Jones and was asked about the payment. And Miss Wilson stated that she had transferred most of it to her father when he was in financial difficulty, and he needed it to pay for his wife's cancer treatment. She said that she owed it to him as when she got divorced, her father assisted her financially while she was not working. And then she used the rest of the payment to pay her credit card debts and everyday living expenses. And finally, she would have faced wholly disproportionate consequences if an order was made, because she would have to sell her family home in order to to pay the restitutionary order. So the trustees on the back of that made an appeal on the basis of this change of position, the fact that it came out in cross-examination that her position had changed and that she was unable to repay this sum because she'd given it to her father. So the trustees argued that the judge had erred in allowing Miss Wilson to rely on that oral evidence to support a change of position argument. Secondly, considering the change of position and applying it to a preference claim under section 340, and finding that Miss Wilson had established a change of position. So let's have a look at what the law says on change of position and section 340. So I've put there the two cases that were considered by the judge in this case, and the slides will be available afterwards, so you can come back and get any reference that you need. But essentially, where a court is concerned with appropriate relief to be granted in a preference or transaction at an undervalued claim, weight could rarely be given to a change of position by the preferee or transferee whilst honouring the policy behind the statute. So the appeal judge in this case took the opportunity to lay down the correct approach that should be made in where a change of position defence is ran. So firstly, change of position is no defence to a section 342 claim. In exceptional circumstances, the facts would establish a change of position would be a factor to consider when the court is determining how to use its discretion as to the appropriate order for restoring the position. And thirdly, change of position alone is not a strong factor because of the underlying policy considerations and the difficulty of balancing the interests of a class against those of an innocent transferee. And you might be thinking, well, it was a factor that was considered in this case by ICC Judge Jones. However, there were comments made by the judge that were wrong in his approach to relying on the change of position by Miss Wilson. So the decision on appeal was that the judge was wrong to take the approach that the change of position was a strong factor with significant weight. Miss Wilson in cross-examination did not justify finding as to how much of that payment had been used to fund the transfer to her father. And therefore the judge was wrong to conclude that Miss Wilson had proved with sufficient clarity how much of the payment was used for a purpose other than daily expenses or existing debts. However, despite all of that, and the court disagreeing with the judge's approach of exercising its discretion, the conclusion to grant relief was still correct. The factors took the case out of the norm such that making of any order would be unjust. So the instant case was very unusual, where this balancing exercise was appropriate. The creditor-transferee contest was between a single creditor who might only gain a small increase in his dividend, i.e. this being the son, depending on the bankruptcy costs, and the judges find that Miss Wilson, also a creditor, would suffer significant consequences, especially losing her home if she had to repay. So this is quite different in the sense that you have a 1 versus 1 setup where you've got one significant creditor against another creditor, and the judge here could balance their interests in the sense that if one was made to repay it because she was preferred, she would have lost her home where her and her daughter were living against the bankrupt son, who would have got a small increase in his dividend. So I think the takeaway message that I would probably provide here is that if change of position defence is going to be run, it should be clearly evidenced. It should form part of the pleadings. In this case, Miss Wilson raised this while she was being cross-examined by the judge. So evidencing change of position is a very important thing to do because we don't want to be in Miss Wilson's case. However, it's also important to realise that change of position in itself is not a defence and will be considered against the whole circumstances of the case. So I do hope that helps, and thank you very much for listening. And like Greg has said, if there are any questions, then feel free to put them in the chat function or drop us an email. Thank you.
Right, I've got 6 scenarios for you, which I think are realistic ones that might come up in practice.
and I've linked them to recent cases, so hopefully you get 2 for 1 from me. If we were in person, it would be good to have a degree of interaction, but sadly, I'm afraid you're just going to have to listen to me for 30 minutes. Right, so we've got a couple of characters who are going to feature throughout our scenarios. Claimco, the litigation funding company, and the long-suffering Boris, as we will see. Claimco's taken an assignment from liquidators of breach of duty, wrongful trading, and Section 423 claims. They've commenced proceedings in the BPC in Birmingham, of course, by way of Insolvency Act application against Boris, relying on 212, 214, and 423. You're acting for Boris. Has Claimco made any procedural errors? And if so, is it worth doing anything about it? So this brings into play the Manoletta Partners case and the decision there he is of ICC Judge Briggs from last year. The facts were pretty similar to the scenario I've painted, although there was, rather than a wrongful trading claim, there were TUV stroke preference claims which were made as part of the application. So what did Judge Briggs decide in relation to the 423 claim? Were there any procedural errors in that being brought in the manner in which it was? He said, well, those claims don't actually fall within Insolvency Rule 1.35. I know that'll all be absolutely at your fingertips. That's the rule that says which applications can be made by way of Insolvency Act application notice. That covers parts 1 to 11, but section 423 is actually tucked away in part 16. And the reality is it's not actually, quote, an insolvency proceeding. It can be brought, in fact, it doesn't even have to be brought in the BPC. It could be brought from the Queen's Bench Division, the County Court. And as most of you, I'm sure, will be aware, that's because, in fact, it doesn't have to be brought by an insolvency office holder. It can be brought by private litigants as well. So Judge Briggs said, well, you shouldn't have brought that by Insolvency Act application. That should have been brought by way of a Part 7 claim. What about the 212 claim? So that allows misfeasance claims to be brought in the name of the OR, the liquidator, or any creditor or contributory. It does not apply to administrators. And I've had more than one occasion where people on the other side have not spotted that and have brought applications in the name of administrators. And it's really just a convenient procedural route. The cause of action remains with the company, and indeed it doesn't affect limitation periods and things like that. And Judge Briggs said, although the office holders can assign claims, the office itself cannot be assigned. Therefore, just as a matter of simple statutory construction, Manolette was not a creditor or contributory and was not within section 212. So what should happen? Well, he said neither claim was invalidated per se, or on the facts, an abuse of process. He also said the court won't assume abuse in cases like this, but didn't, perhaps unhelpfully, give any guidance as to when abuse would arise and when it wouldn't. I think there's an argument to say that following that case, deliberately issuing proceedings using Insolvency Act application notice when it should be Part 7 may well be abusive, because certainly until this case, there was certainly a pretty common practice to lump in 423 claims along with, for example, TUV claims, which are properly brought by way of Insolvency Act application. And certainly the cautious approach is to separately issue Part 7 claims and then try and tie them up. I certainly think that if you just issued a 423 by itself, using Insolvency Act application notice without linking it up with a claim, for example, a TUV or preference, which is made by Insolvency Act application, I think that could well be abusive. Judge said, sorry, just go back. Judge said he had a discretion to permit to continue if it's procedurally convenient, sensible or economical. And he allowed the claims to proceed with the payment of the appropriate fee. And as we all know, this is really about money. The court fees for Part 7 claims could well be up to £10,000, much lower sums for Insolvency Act application notices. So he allowed them to proceed with the appropriate fee. But he made the comment, and it's pretty obvious, that there needs to be some amendment, certainly to the rules, and probably to section 212 as well, to allow assignees to bring claims under that procedure. As far as I'm aware, there's no proposals in that regard as yet, but that's something to look forward to. So going back to your advice as to Boris, I think there is some point to be taken. At the very least, you can probably put the other side to the expense of paying the court fees, although you may ultimately want to take a view whether Boris is likely to be liable under the claims and therefore liable to pay the £10,000 on top of any other claim at the end. Right. Now, let's just say you took a different view and the judge ultimately required Claim Code to issue Part 7 proceedings in relation to misfeasance claim. Let's say it's then managed with the ongoing claims for wrongful trading and 423. Boris is also a creditor of the company. He's got an unpaid director's loan of 100,000. And he's just really not very happy about the assignment to Claim Co because it was not offered to him first. And he says he would have paid more. Query what exactly that means. Can Boris challenge the assignment under section 168(5 of the Insolvency Act? And what are Claim Co's likely arguments in response? I think as we've had more assignments as a result of the intervention of claims companies, so challenge to assignments, I think, are certainly on the rise. Well, this was considered by His Honour Judge Halliwell, looking suitably judicial there, in the recent case of Edengate Homes Buckley Hall Limited. He referred to the well-known fact that a person aggrieved within 168(5) includes a creditor. A creditor is not a stranger to the liquidation in the language which is used in the cases. But that's not enough. Going back to the Privy Council case of Deloitte and Touche, which many of you have come across, it's not enough to come within the wording of the statute. You've also got to have a legitimate interest in the relief sought. And that decision was applied very recently by the Court of Appeal in the long-running Brake litigation. And you've got the reference there. And the upshot of Brake and Edengate is a creditor, Boris in our case, will not have such an interest if he's acting otherwise than in accordance with the collective interests of the estate of the whole. So in Brake, creditors were being funded by the bankrupts, and their only purpose in challenging a particular transaction was to advance the interest of the bankrupt. And the Court of Appeal said, even though if their applications succeeded, that might have produced a better result for the liquidation estate, the fact they're acting solely for the bankrupt and solely adverse to the interests of the other creditors meant that they didn't have a legitimate interest, which in some ways is quite a striking result. In Edengate, that was all about trying to avoid a misfeasance claim. I'll come on to the detail now. What Judge Halliwell held, that the creditor was motivated more, come back to that, by an impulse to protect the interests of herself and members of her family who were facing claims by Manolete, and to maximise returns for creditors. And the judge said, however laudable this might be perceived, it is inconsistent with the collective interests of the creditors as a whole, and more specifically their interest in the relief sought. So just pausing there, before we get into even scrutinising the liquidator's decision, the judge said no standing to challenge the decision and the assignment at all. Now, I can certainly see a case where if a person is acting solely in the interests adverse to the estate, they don't have standing. But when the judge said the creditor was motivated more by an impulse, that doesn't suggest that was the sole criteria. I think perhaps future cases need to consider with perhaps a little bit more care whether or not this, we're talking now about a substantial or a dominant purpose which invalidates the standing to challenge the assignment. It seems wrong to deprive a creditor of the right to challenge something just because they might have had some alternative motives. Anyway, that wasn't developed in that particular case. And the other element is, even if you have standing, of course, it's a high bar for a creditor to get over. It's the perversity test, so Wensbury unreasonableness. In that case, the creditor was impecunious, probably not a good start, no evidence more would have been paid by the creditor, the liquidator had explored other options, and then probably crucially, he got a reasonable rate of return, 50 to 70% of the net proceeds after the first £30,000. So even though it hadn't been offered to the creditor, the judge wouldn't have found it to have been a perverse decision. And those of you who are getting to be as old as I am will probably remember the Eden Note case in Terry Venables, which took a very different approach. It seems that standing wasn't argued in that case. And then on the facts, it was quite a low rate of return. I think it was £7,000 plus 10%, which was very different. So compare and contrast those cases if you have this type of issue that arises. But I think in relation to Boris, given that probably his sole aim is to try and avoid the misfeasance claim, he's probably not going to be in a strong position to challenge the assignment, and maybe better spending his money elsewhere. And elsewhere, there are other ways to spend his money. So Claimco alleges wrongful trading from April 16 to some later date prior to 25th of April 17. So obviously not particularly happy with that as an allegation. So you raise some Part 18 requests, and in answers, Claimco identifies 10 separate and alternative dates for wrongful trading. But the pleadings do not identify the increase in net deficiency on each of the alternative dates. And it said, well, this is just for expert evidence. We don't need to do it at this stage. Boris, he's done his own research. We love those clients, don't we? Complains to you he doesn't understand the case he has to meet. And running so many alternative cases must surely be an affront to the overriding objective. Is he correct? Well, there's really two different points here. One is, do you need to plead the increase in net deficiency? And secondly, is 10, frankly, just too many? So this brings in the BHS group case. We can see there, yeah, half price. We know where that all ended up. And the decision of Deputy ICC Judge Schaffer. Now, in that case, there are only 5 alternative dates, but the complaint was made, you haven't identified the increase in net deficiency on each of those dates, should be struck out. Judge said no. First of all, the respondents knew the case at this stage, which they were required to meet. And importantly, the issues were identified for disclosure and for witness statements. And the judge took the view that the increase in net deficiency could properly be dealt with expert evidence. And also importantly, the parties had agreed basically the earliest possible date, and therefore the respondents knew their maximum liability, so they could make Part 36 offers if they sought to. They could make provision for that maximum liability. And there was delay in the case, but the judge just expressed his disapproval, which didn't take matters much further. So going back to our 10 alternative dates, you can probably advise Boris that failure to plead the increase in net deficiency isn't a drum worth banging at this stage, but certainly 10 alternative dates. I certainly think in correspondence, the directions hearing, you could persuade the district judge or the ICC judge to engage in pretty robust case management to see whether 10 is really appropriate, whether or not it should be paired to something shorter than that. Right, so further evidence emerges. Claimco bins the wrongful trading claim and the 423 claims, but pursues 2 separate misfeasance claims. Just deal with the first element. So Boris entered into a pre-pack with the former administrator Teresa at a gross undervalue. So it's admin, then liquidation, different office holders, and it was a pre-pack with Teresa. And it's alleged that Boris knew as an undervalue, but in breach of fiduciary duty, he failed to disclose relevant information to Teresa that might have led her to identify the true value of the business. So you've drafted some pretty careful points of defense. You deny as a matter of law that it's possible for him to be liable as a director post-administration. Some pleadings on the facts, we don't have to worry about those. Now, Claimco is threatening to make an application for summary judgment or strikeout on a point of law in relation to number 1. It says the point of law has previously been determined by an ICC judge and it's plainly correct. Now, just assume that Boris's management function came to a complete end on the appointment of Teresa. What arguments can you marshal in opposition? Is that point of law obviously wrong? Obviously, the court does have power to deal with short points of law, but importantly, and although it's reasonably well known, one sees time and time again judges getting caught out by this. It's not appropriate to strike out a claim in an area of developing jurisprudence, because where you've got a novel point, it should be decided on actual findings of fact. That's always worth, an important point, always worth bearing in mind. So is this a novel point or is it determined? This brings into play the decision of Judge Barber, there she is, in System Building Services back in 2020. Now, in that case, the relevant allegation was the director had breached the duty to have regard to interests of creditors in purchasing I think it was domestic property at an undervalue from the liquidator of the company in CVL. Now, our scenario is admin, this was CVL. Now, in the points of defense in that case, it was admitted the duties as applied, but then there was some rowing back at trial, and the argument, the respondent was allowed to argue the duties didn't apply. But one can't help but feel it's a bit of an afterthought, and the arguments weren't marshalled nearly as well as they could and should have been. Anyway, the director said, look, I didn't negotiate the purchase of this property as a director. I can't be in breach of duty. Judge Barber said, I don't agree. Rejected the director's argument and found him on the facts to be in breach of his duty by not disclosing certain information to the liquidator. I mean, reading between the lines, I think the liquidator should jolly well have known everything about it, but there we are. So the judge's reasoning, briefly, was, well, there's a number of provisions which make it clear either your duties as director continue after you resign, or that just receiving a benefit in the position of a director is sufficient. And therefore, it's not necessarily actually to do anything as a director. She said, the Companies Act in a number of respects specifies when it does and doesn't apply in certain situations, and the general duties don't say they don't apply once a company's gone into CVL or admin. 172 preserves the duty to act in the interest of creditors, and she said entry into administration or CVL does not of itself result in the removal of directors from office. So the judge couldn't see a way in which the duties ceased or were modified, and held that the director was in breach. But I'm going to give full credit to Rob Mundy for these arguments on this slide, which are contained in his very good article, which he wrote last year. If the company had been in compulsory liquidation, then the director's appointment would have automatically terminated. And he couldn't have been liable on the facts, as the judge found. So what's the difference? Why should the director be under a different obligation in admin and CVL as compared to compulsory liquidation? There's a Court of Appeal decision called Plus Group and Pike. It's not an insolvency case, but in that case, the director had been effectively expelled from the company, and it was held that his duties had been reduced to vanishing point, because in reality, he wasn't involved in the management and couldn't be involved, and therefore couldn't be in breach of duty. A close analogy can be drawn with this situation. And then we turn to the content of the duty. You've got to act in the broad terms, the best interest of creditors. So have you got to pay the most that you'd be prepared to pay? Let's say it's worth 200,000, but in fact, you'd be prepared to pay as a director 250,000. Are you in breach of duty by not offering the maximum that you'd be prepared to pay? This is all starting to feel quite unworkable. And then what about different kind of assets? In that case, the liquidator held a domestic property. What happens if there's a cause of action against the director? Is the director supposed to reveal all facts relevant to that cause of action and only to make reasonable offers of settlement, which reflect his true liability rather than what the liquidator has at that point discovered? I know there's complexities with the duties to provide information as director post-liquidation in terms of books and records, but it does start to really make it rather difficult to see how this is supposed to work. Some further points. when a director enters into a contract or an arrangement with his own company, you have to make a declaration under section 177. So disclose it to the board of directors unless they're otherwise aware of it. But hang on a minute, post-admin, post-CVL, assuming it's not a light touch admin, for example, the board is a name only. The relevant management powers are vested in the office holder. So surely it should be to the office holder that any disclosure is made, but that's not what section 177 says. And surely section 177 should be working in harmony with the other provisions. And if it can't apply in this situation, that's a signpost, I would suggest, that 173 and the duty to creditors doesn't apply either. And perhaps the neatest way of looking at it is section 175, which applies to the duties of shadow directors. And it expressly says those duties apply where and to the extent they are capable of so applying. And what I would suggest is that provision should be applied by analogy, post-admin and post-CVL, to directors' duties. If they have no management function, then they should not be subject to duties such as the type found by Judge Barber. Obviously, if they are involved in management, then clearly they have some responsibility remaining. So I think coming back to the position, the law isn't settled. It seems to me this kind of issue is going to have to go before a High Court judge and possibly the Court of Appeal, and to be argued rather more fully than it was first time round. Right, so result of part settlement. The only remaining issue for trial is in fact the remaining misfeasance claim against Boris. Essential allegation is at the time when there was a real prospect of the company becoming insolvent, Boris paid himself 100,000. Records are not as clear as they might have been, but there's a draft minute declaring an interim dividend in that sum. Boris gives you instructions, says, well, this is only a draft minute. And really, this was really salary, wasn't it? For the 80-hour weeks I was working. And you pop this into his witness statement. At trial, Boris is asked whether he caused the company to pay tax on the 100,000. Boris says no, but he's sure he wrote a memo to the company's accountant saying it should happen. Fortunately, he can't produce the memo because the company's records were destroyed in the mysterious fire in the office shortly before liquidation. I really do think that someone needs to do a serious academic study as to the rate of fire, floods and theft in companies immediately before they enter into an insolvency process as compared to general companies. I think the results would be interesting. Anyway, after cross-examination finishes, Boris asks you whether you should accept an offer on the table of 80,000 from Claimco, which remains on the table. What do we think? A little bit of assistance. Recent decision from Judge Burton, Bronya Buchanan. No new principles, but a really good summary of some important points. Okay, once a payment has been made to a fiduciary, the burden is on them to explain the transaction. In the absence of contrary evidence, a transaction was what it appeared to be. And then it's not open. This is now a consistent theme that's come out over a number of years in the cases for a recipient to recharacterize a transaction or recreate history after the event in order to suit them. It also identifies and just confirms the problem with quantum merit claims. There will be no implied contract for remuneration when that has to be dealt with in accordance with the articles. In any event, it's an unsecured claim in the liquidation, excuse me, which cannot be set off against a misfeasance claim. So returning to the facts in our case, available evidence does rather suggest it's an interim dividend rather than a salary. Sequana obviously says if it's a dividend, you got a problem because it's an undervalue. Can we really see that it was right for Boris to pay himself 100,000 in the scenario? Should we be taking the offer? Quite probably. Right, last scenario. Just change the facts and assume the claim against Boris was rather more serious and involved in making secret profits as a result of a Ponzi scheme. Now, the court makes an order saying, as a result of breach of duty, Boris holds the property on constructive trust for the company. Boris is then even worse for him. Convicted of offence of dishonesty and confiscation orders are made under POCA. Which takes priority? So I know, I think Ali and Kirsty briefly referred to this case earlier this week, Aquila Advisory. In that case, directors exploited their position as directors to make secret profits of 4.5 million odd through promotion of fraudulent tax avoidance scheme. CPS, unsecured creditor, in respect of confiscation orders, appealed the decision of the judge and the Court of Appeal all the way to the Supreme Court about the constructive trust decision, because basically CPS wanted their confiscation orders to take priority. And how do they go about arguing this? They said their fraud of the director should be attributed to the company, so the defence of illegality applied. And there's more general public policy argument, POCA basically should trump everything, which is the kind of argument you might expect a prosecutor to run. Anyway, on the first point, the Supreme Court went back to Bilter, which provided a lot of clarity and good sense in this area of law after the madness of the Stone and Rolls case. Bilter confirmed that when a director is sued by a company for loss, the director's knowledge will not be attributed to the company to prevent it from bringing a claim against it. CPS said, well, this is a bit different. It's not about loss to the company. It's about profits made by the director, which if they hold on constructive trust, will mean the company generates a profit from its own fraud. One can see the argument, but the Supreme Court, I think, favouring simplicity more than anything else and a clear rule. No difference whether the claim is for loss or for gain by the directors. And they also said Patel and Mirza doesn't apply here, doesn't change the position. So a nice clear rule basically paving the way for claims against directors by companies in liquidation or other processes without hindrance of arguments such as illegality. And it's quite striking, as I say, notwithstanding those factors, dishonest state of mind was not attributed to the company. And as to the more general public policy argument, no. Basically, POCA does not interfere with third-party property rights. And as a matter of public policy, there was nothing inconsistent with the decision reached with the aims of POCA. So the appeal failed on that ground as well. So it was, prosecution ended up being 2-0 down. So those are my scenarios. I'll just end the show. And back over to you, Rob.
Thank you, James. It looks like we've got a few questions, 2 on assignments. The first is this, the delegate asks, can I just double check, did you say the Manolete case decided that section 212 claims can't be sold or assigned?
No, so they can definitely be sold or assigned. That's clear from the provision in the Insolvency Act. The question is how those claims are then brought. As a signee, you can't rely on section 212. What you have to do is to bring the claim by way of a Part 7 claim. That's the important difference.
Section 212 is just the gateway available to insolvency practitioners to get to court a bit quicker and at considerably less cost.
Yes, exactly. I suspect in due course 212 will be amended to include within its categories of people that can bring it by that cheaper and quicker method, administrators and also assignees of claims from office holders.
And then the second question about assignments. In a challenge to an assignment by a creditor, do you think the courts will treat differently an assignment to a creditor for a fixed sum of money on the one hand, an assignment to a claims company typically for a percentage of the proceeds?
Yes, I mean, I don't think it makes a difference to the standing point as to whether you've got the standing and legitimate interest to challenge it. But if you get to the second stage of looking at perversity, the court is going to be interested in whether the liquidators sought to get a good deal for creditors, and whether the liquidators explored, all reasonable options, I would say, to get more money for the estate. And it will then be required to consider and compare what the liquidators got from the assignment, what it might have got from other people. So if the deal doesn't look very good, makes it more susceptible to challenge. Whereas if the liquidator's got an upfront payment plus a decent percentage, that's going to be maybe pretty hard to challenge.
And then I think this is the final question, unless any come in the meantime. James, you're asked, could you clarify the applicability of the point you made about the continuing duties of directors in MVL and CVL? I think you mentioned CVL, perhaps you could clarify that and then discuss it in relation to MVL.
Well, I think if you follow Judge Barber's reasoning, the director's duties would continue in MVL in the same way as in CVL and by way of implication in administration. And those three have to be put on one side as compared to compulsory liquidation, where the case law is clear that you're effectively out of office with no duties. For the reasons I gave, I think Judge Barber's probably wrong, and therefore it's a more nuanced approach in CVL, MVL, administration, depending on what, if any, management function the directors are performing. And in most MVLs, they wouldn't be.
Excellent. Thank you, James. Thank you, Raghav. Thank you, Amanpreet. Thank you all very much for joining us this week. We've enjoyed your company. We hope you can join us again next year. Perhaps next year we'll meet in person. In the meantime, enjoy the rest of your working day and have a lovely weekend.